Now the race between Robert Hunter and Abraham Jones. We're going to begin with Judge Abraham Jones, former Superior Court judge and now attorney in private practice. The question for Judge Jones is as follows. Rule 30E3 of the Rules of Appellate Procedure states that the citation of unpublished decisions of the Court of Appeals is disfavored, but it goes on to describe how a lawyer is to utilize such an unpublished opinion if bound and determined to do so. For years, there has been debate among appellate lawyers and judges regarding the proper role of unpublished opinions in the development of a coherent and consistent body of law to help govern North Carolina's business and personal relationships. What is your own view of the value and proper use of the court's unpublished opinions, Judge Jones?
Good morning, everybody. My name is Abe Jones, as he said, and I was a Superior Court judge in Wake County for 17 years, between 1995 and 2012. I'm going to talk to you, I'll deal with the question right at the end because I don't think it's very complicated. So I'm going to tell you more about myself and why I'm running. I've been a lawyer since 1977. I've done just about everything that a lawyer can do. I've been a prosecutor for the federal government, a prosecutor for the North Carolina out of the Attorney General's office in Medicaid fraud. I've also been a defense attorney for the federal government in the U.S. Attorney's office in the Eastern District, as well as a defense attorney out here in private practice where I've defended people charged with crimes. In my role working for the government, both the state and the federal government, I did a lot of civil defense, as you might imagine, for the United States government under the tort claims and also Title VII. Also with the State Attorney General's office, when I was in Medicaid fraud and tort claims, I got all over the state, and I recognize that it's important to have good lawyering on whichever side of the issue that you stand. I'll tell you a little bit more about my background. I was born in Wilson. I just came from Wilson last night, great part of the state. I'm an Easterner. I love the East. I was born in Mercy Hospital. My parents were teachers. And I left Wilson. I was raised in Raleigh primarily. And I came out of a family of 7 children. I'm the third. I went to Harvard College and Harvard Law School on scholarship. I got out and I clerked for the district court in Washington, D.C. Then I clerked again for the D.C. Circuit. Then once I got to the Attorney General's offices, I had to write a brief a month coming out of criminal appeals, and we did that. So I've had a lot of experience with the writing of briefs and the writing of papers and memoranda. I think it's very important to have a judge on the court who's had broad life experience. I've represented people, big people, so-called little people, companies, the government. I've been on all sides of the issues. And I think it's important to have diversity of experience on the Court of Appeals, both in terms of your life experience and your legal experience. And I would bring that lens to the court. Also, I think that it would be very important to have someone who's run a small business. I've run my small law practice twice, and I think that's an important experience. What it's like to be a little guy, not just a big guy. And so I think that's important. Now, let me deal with the question about 30E. Frankly, I think all decisions should be published. That's my opinion of 30E. But since you have it, I think it's important that we should attach it whenever we cite it. And the problem with the 30E rule, where you can have unpublished decisions, the problem with unpublished decisions is that it's still the court adding to the body of law. If the body of law is added to, by God, it should be published. That's where I feel. Since it's not published, then you should expose it and attach it. and that's the answer to the question. I think it's very important also when it comes to the Court of Appeals that you have judges who understand what it means to represent people who have been on the other side of the law. The prisons are filled up with primarily African American males. I'd say about 85%. How much time do I have left? 1 minute, yeah. And you need somebody who has gone into jail cells and talked to real people and listened to them and understand what it means when you're up against the system. I understand that. I've been part of the system, I've been outside the system, I've been on the bench, and I ask for your support. You can go to my website, voteabejones.com, and read all about me. I would love to serve you on the North Carolina Court of Appeals, just as I served you on the Superior Court for 17 years. Thank you very much.
And thank you, Judge Jones. And now, current Court of Appeals Judge Robert J. Hunter, Jr. The question for Judge Hunter is this. As lawyers representing parties that have been sued, it can be quite difficult to accurately predict what a judge or jury might do in a given case, particularly in those cases involving severe injuries or otherwise sympathetic plaintiffs. Pursuant to North Carolina Rules of Civil Procedure 12, 50, and 56, the court is required to remove a case from the jury when justified by the law and the evidence, regardless of the consequences to the parties. But we find that many judges are reluctant to consider doing so. Please state your philosophy about the appropriateness of such dispositive motions in civil litigation. Judge Hunter.
Thank you, Mr. Hood. I want to thank the organization for inviting me here today. I feel like I know so many people here, and I know your organization. I was pleased to receive its endorsement during my last race for the Supreme Court based on the body of the work that I have produced. And I would look forward to your endorsement again this year. I have eaten barbecue with you and shrimp and gone around the state to various meetings where we have a chance to meet. And based on the evidence that I've seen in my position as a judge, I judge y'all fabulous. I'm going to address the question first because I think we need to talk about what I'll call is the burden of proof. And I don't have to teach you guys what the burden of proof is, do I? You know what the burden of proof is. And when somebody is an incumbent and is doing a good job, the challenger has a job, or the proponent of a change has the burden of proof of saying that a change is necessary, that somebody needs to make a change. I've heard nothing today that has indicated that I need to be put back in private practice. The work of the court is a great love of mine. I enjoy my service. I love the law. I love the work I do. And I think it's important for someone with great experience and relevant experience does this job. You can read my work. You know where I stand on various issues. I'm fair to all litigants. I'm independent. There have been a couple suggestions that have been made that somehow one's partisan affiliation or political or philosophy may lean one way or the other. And I do want to address my own political philosophy. I don't know if you've noticed this or not in your experience in reading the paper and all, but sometimes the legislature and the executive mess up. And it takes a strong judge to remedy whatever they may have messed up. I don't hesitate to try to do that in my experience. Now, we don't get to do it very often because most of the time we are applying routine law to settled matters. And I think I'm okay at that too. 35 years of practicing law in Greensboro with single practice, multi-practice, a 200-man international, 200-person, excuse me, Linda, a 200-person firm from Washington. I have a pretty good sense of the law, the defense, and where people are and their categories and what is a fair thing to do in most cases. I'm blessed by being endorsed by what I'll call a very diverse group of characters. The Sierra Club, the Friends of the Fraternal Order of Police, Police Benevolent Association, the North Carolina Association of Educators, and then a host of conservative organizations and judges of both races and both political parties. So I'm very happy with the people that have endorsed me and would like for me to stay on the bench. The question that I've been asked to address has to do with what I think of as a very obscure procedure. I've never used those rules to take a case out of the hands of a jury, and I quite frankly didn't know they existed until I read the question. I've never seen it come up at the Court of Appeals. So whoever's writing these questions, I would like to speak with after the meeting. My general philosophy is the reason I think judges are reluctant to do it is because we have a constitutional bias in favor of jury trials in civil and criminal matters. And that if I were the judge in a courtroom, I think that and it was a case involving that might be in that position of taking it away from the jury because it involves a serious injury, my inclination would be to deny the motion at directed verdict and then wait and see what the jury actually did. And then if there was a good cause for it, then you could take care of it under judgment notwithstanding the verdict. And I think there's plenty of remedy now, and certainly in the punitive damage area, for appellate courts to review excessive verdicts. And certainly in North Carolina, we can't say that our legislature hasn't been attentive to the needs of the defense bar in keeping verdicts down. I appreciate your donations and your support. I'll be here for lunch if anyone has any individual questions. Thank you.
And thank you, Judge Hunter.